Before taking this class, I genuinely believed that signing a medical consent form meant you couldn't sue if things go wrong afterwards because the risks were explained to you. I didn't have any evidence for this belief, nor did I hear this from anyone. It was just something that felt true, and so I accepted it as a fact. I thought that once you signed your name on a consent form, you were legally accepting the risks of whatever you agreed to. Whatever happened next was ultimately a decision that you had already made. In our day to day lives, we sign legal documents that actually do waive our right to sue, like liability waivers and settlement agreements, often without fully reading them. For example, every time I go to an indoor rock climbing gym, I'm required to sign a liability waiver before I'm even allowed to climb. That waiver covers the gym for inherent risks like falls, injuries, and even equipment failure. And so I naively assumed that consent forms worked in the same way. I thought medical treatment was basically like a rock climbing gym. If I wanted to quote unquote climb, meaning receive treatment, I had to give up my right to sue no matter the outcome. And I think a lot of people think about consent forms this way, as liability waivers. But after learning about consent in health law, I realized that this belief is truthy and not actually truthful. In reality, a signed consent form works very differently than a liability waiver. Consent forms do not excuse medical negligence, and they do not protect healthcare providers from liability if something does go wrong, which is what a liability waiver would do. According to leaders in law, a database which provides people with lawyers in specific practice areas, a consent form does not give doctors permission to be careless or ignore professional standards. Even after a patient signs, health providers still owe a duty to act competently, carefully, and in accordance with accepted medical practices. This is because fundamentally, consent forms aren't even about waiving your right to sue. They're about documenting informed consent. Under Ontario's Healthcare Consent Act 1996, consent must be informed. That means the patient must actually understand the nature of the treatment, the expected benefits, the material risks and side effects, reasonable alternatives, and the consequences of refusing treatment. Moreover, a signature alone does not provide proof that this understanding even happened. In fact, legal and clinical professionals emphasize that informed consent is a process, not just a piece of paper. As explained in an article by Consult Pro, consent requires a real conversation, one where patients have the opportunity to ask questions meaningfully and understand what they're agreeing to. This idea is clearly illustrated in Reid versus Maloney, 2011. In this case, a patient signed a consent form before undergoing treatment. After complications occurred, the patient argued they'd never been properly informed of the material risks. The doctor relied on the signed consent form as proof that valid consent had been given, but the court rejected that argument and emphasized that a signed consent form is only evidence of consent and not proof that the patient actually understood what they agreed to, or informed consent. This case directly challenged my idea that you can't sue if you sign these forms, since the signature on a consent form does not act like a signature on a liability waiver. So while consent forms may look like liability waivers and they might share some similarities, under the law they work very differently. In healthcare, consent is not about giving up your right to sue. It's about making an informed choice about your care, and patients may still be able to sue even after signing a consent form when that choice wasn't truly informed. For example, if material risks weren't disclosed, reasonable alternatives weren't explained, or the patient would have made a different decision had they had been properly informed. So while the statement, if you sign a consent form you can't sue, feels true, the law shows that what really matters isn't the signature, it's whether consent was truly informed. This is a good example of a truthy statement, but not actually a truthful one.